Did you know that fix and flippers can be sued for construction defects for up to 10 years after selling the property? I'm reviewing a case right now out of Nebraska where the sellers are being sued for more than $50,000 for issues the buyer's claims were hidden during the sale. As an attorney who reviews litigations for over 100,000 business entities, I've noticed a pattern. Fix and flip investors who've been successful for years suddenly losing everything and having their business come to a dead stop because of a lawsuit on a property they sold a long time ago. And today I'm going to reveal exactly the entity structure that prevents these past project lawsuits from destroying your current business and the current properties you're working on. Hi, I'm Jonathan Feniak. I'm the lead attorney for LLCattorney.com, and I help real estate investors and fix and flippers protect their assets and create structures for their business that maximize their legal protection and limit their downside. Let's start with the reality. In most states, construction defect liability can extend for 6 to 10 years after a property is sold. What this means for you is that you could have done work on a property in 2015 and could be sued for defects related to that property today. Just last month, I reviewed a Nebraska case where the buyers are suing the sellers for more than $50,000 because that's the estimated cost to repair all of these issues they claim were hidden from them. The buyers allege things like the sellers concealed serious mold problems, faulty wiring, plumbing issues. And if we look at those, we say, well, the mold, maybe their contractor didn't tell them and they just painted over it. The faulty wiring, maybe the contractor wasn't a licensed electrician. Maybe the plumbing issues were also due to unlicensed work. Also, think about if you're doing the fix and flips yourself, if these are the kind of things that you may potentially run into, right? Fix and flips, there's huge opportunity, but if you cut corners, you could be on the hook for a long period of time. So they're claiming that these issues were not disclosed, and they were violations, failing to disclose them were violations of the real estate disclosure laws, and they were a breach of the purchase agreement. So the most common mistake I see with real estate investors, they use a single entity for a long period of time for all their fix and flips projects. And this is dangerous, okay? It leads to an asset commingling where you've got all of your properties and cash in one legal bucket. You've got all of this equity from your current projects exposed to that prior risk. You've got unlimited, really almost unlimited liability time frame. The entity remains exposed for as long as that statute of limitations will allow them to bring that claim. And remember, it could be a claim can be brought after discovery. There could be a 5 years unless discovered, and then maybe they've got 2 years from the discovery period. So that is a real long timeline in this potential liability. Another one is going to be this concentration of risk. You've got one lawsuit that could affect all of your current projects and really all of the profit you've made potentially from those prior projects. Another mistake I see is creating a new LLC for each property, but then dissolving it immediately after sale. This is going to be a problem, right? Because the courts will go to the owners of the company if the entity is dissolved, and they may go after your personal assets because they can't sue that entity anymore. It does not exist. So that is not a fix for this, is to do one and done. Some states have specific laws that extend the liability and impose that liability on the owners, on those who took the distribution from the company after dissolution. And that dissolution could actually be evidence of bad faith, right? You're trying to run away from problems. And so another problem I see is that investors create complex structures with dozens of entities that are unnecessarily complicated, and they're really not treating them as separate legal entities. They are taking one fix and flip, they put it in its own LLC, but then it doesn't even have a bank account. It doesn't pay its own expenses. They're doing all that through a holding company or a construction company or something else. In that way, that business entity is not really being respected, and we can't expect the courts to respect it. So I don't see creating dozens of LLCs for multiple projects that are working at the same time as being a viable path, and it's going to be very complicated and expensive to do it right. I see land trust as potentially a solution to this, with land trust owns the property, but then you've got an LLC as trustee, and the LLC as trustee can be liable. So if the LLC as trustee has other projects it's working on, it creates more complexity in running it properly, operating a land trust properly, and it can create this false sense of security that you don't have to really worry about the liability from these prior projects. I think that's a mistake. These mistakes happen because most real estate education focuses on finding, the deals and maximizing the profits, but rarely address this long-term liability problem that comes from having this business that's done a lot of fix and flips over time. The solution. I haven't heard anyone talk about this. This is a secret between you and me. I call it the annual entity strategy or the vintage strategy. Here's how it works. Create a new LLC each calendar year for that year's projects. You run all the projects in that single LLC, so you can share expenses across them. Go buy a whole truckload of tile. One company's going to buy the tile, and you can use it on those 10 projects for that year, right? So you can share expenses. You can manage it as a single unit. All the properties are finished in that entity for that year. We got a 2025 vintage or annual entity. Once all those projects are sold, and they could not sell potentially. It could take 18 months to finish a project. Maybe they're not sold until 2007. That's okay. Okay, you're going to maintain that entity. You're not going to immediately close it. You're going to keep paying its insurance for a couple of years, right? You're going to make sure there's nothing percolating. And I say, the statute of limitations can be very long. It can be 10 years. But what I've seen is that in most cases, within a year or two, these claims are being brought. People are not bringing them a decade later. That's going to be really, really rare. But you're going to keep the entity open for a minimal cost. You're going to keep some money in its bank account. You're going to maintain it in good standing with the state, but it's going to be a fairly dormant entity, and you keep it in place until the statute of limitations expires. Yes, you're taking on a little bit of cost, right? But you're protecting those future projects. You're going to then wash, rinse, and repeat, as I like to say. So you have your 2025 vintage, you'll have your 2026 vintage, and so on and so forth, and keep repeating the process. Eventually, those entities, you could have, maybe you got 5 entities going, 5 vintages or annual entities going at one time. And then when you're past that statute of limitations, you feel like everything's good, you can dissolve that entity from the earliest year. So this approach creates a clean separation in your project years. It's going to help you manage things in your head a little bit easier too, right? And it ensures that if a lawsuit arises from a 2018 project, you're not going to have litigation against your 2023 LLC. So you've isolated the risk to 2018. If there's any liability that comes against the 2018 entity, and the entity's still around, it can be limited to that entity. Maybe there's a clawback of some profits, right? If the court determines that's appropriate. But I think that's going to be a remote case that they require that. And it's basically an almost empty entity, a little bit of cash in it, but not much else. And their claims are going to fall flat. What it's not going to allow them to do is put a lien on a property you've got in the works right now, right? That can be really disruptive, because you know what? If there's a lien against your property today, in today's LLC, you're not going to be able to sell it. You're going to be locked in until that prior litigation is solved. So here's what you do. First step, I really recommend you have a holding company. Why? Double layer of protection is number one, right? If we get sued in a 2018 vintage and they are able to pierce the veil, they're getting to a holding company, and that holding company is going to protect you from that personal liability. That's going to be number one reason. The number two reason is going to be that maybe you've got a partner you're doing these projects with. Your partner and you would be partners at the holding company level, and then your subsidiary is going to be a wholly owned subsidiary. That's going to simplify your tax situation. You don't need to do it in that way. You could have, if it's multiple partners, each partner can have their own personal holding company. I do want a double layer of protection no matter what. A personal holding company for each of them that owns a partnership that's doing the fix and flips for that vintage or for that business entity year. And then name that holding company something fairly generic. The next step is going to be to form the LLC at the beginning of the calendar year, or if you're starting today, and name it something that indicates the year. Name it something that is the, Iowa Investment Properties 2025 LLC. Get the proper operating agreement, get the EIN, get the bank account set up for it, purchase the properties in that LLC. All the income or expenses are happening in that LLC. It's a really tight business entity where you're complying, you're focused on business compliance. Maintain that separate bank account for the LLC. Don't commingle funds or assets or sort of expenses or any materials across vintages. But within that single LLC, feel free to share, buy your materials in bulk, work on the fix and flips. Keep the records, though, of that business entity separate. Properly document the completion of projects. When you sell the last property in that LLC, document it. Document that there's no anticipated issues with the sale of the property. You're going to keep enough money in the bank account to keep that insurance alive for a number of years, whatever you determine is appropriate. And then keep that entity active and compliant, doing things like annual meeting minutes, maintaining the bank account, keeping in good standing with the state, maintaining your registered agent, and maintain that small enough reserve to anticipate and pay those anticipated potential expenses that are going to come to that business, such as business insurance. Once that statute of limitations has expired, or you're comfortable there's not any problems with the property, you can safely dissolve the entity, pay any final expenses, and distribute that final amount to the owners. So this strategy provides maximum protection with minimal complexity and cost. We're not trying to manage 5 LLCs or 10 LLCs in a year where, honestly, you're probably going to fail at keeping them separate, because you're going to have the plumber go from project 1 to project 2 to project 3 to project 4, and he's not going to give you 5 invoices, right? Or you're going to use materials across the different projects. So if you're doing 3 to 10 projects a year, it's going to mean maintaining, maybe you've got 5 to 6 entities you're maintaining, but the majority of them are going to be almost dormant during that period of time. Some people say, well, what if I've already done multiple fix and flips in my LLC? Start today, right? Let's draw a line in the sand. You can implement this strategy going forward. Yes, you've got a lot of liability that's built up in that other entity, but if litigation comes, we don't want there to be works in progress in it. So create a new entity to do all your future projects in, or at least 1 year worth of future projects. There could be other issues here, right? If that entity that's been doing fix and flips owns equipment, right? Or if it has significant employees, or there's a lot of things that can sort of come into play here. And if you're in that situation, then you should probably schedule time with an attorney to talk about what the best approach is. Hopefully you're now aware there's this long tail of liability that's following you, and I do fully recommend that you evaluate right now whether this vintage strategy makes sense for you. If you're going to continue on this path of doing fix and flips, then I highly recommend you adopt the vintage strategy, form a holding company in Wyoming, form the subsidiary or vintage in the state in which you're doing the flips, and then wash, rinse, repeat, as I like to say. You can do all of this at the LLCattorney.com website, and we've made it so easy to form a subsidiary. There's a button that says Subsidiary company, you press it, you pick your parent, you pick your state, and you can form that subsidiary in, I think, less than 5 minutes is what it takes me to do it. Maybe you're a little bit longer, but it may even be a little bit less. So hopefully you have found this video helpful and you understand the risks that you're facing when you're doing fix and flips, and you have a real plan to move forward and mitigate and eliminate that risk that some project from years ago is going to affect what it is you're doing today. If you like this video and you think it's helpful, stay tuned and watch the next video for even more helpful information.